Back on the record, we're going to begin with the remaining reduction hearing cases. Probably need to swear some people in. City staff's probably already sworn in, but if you're here for a case and we're not here earlier this morning when I placed everyone under oath, I do need to place you under oath, so if you'll stand and raise your right hands if you're going to be speaking to me. Thank you. Do each of you swear or affirm under penalties of perjury that your testimony today will be the truth, the whole truth, and nothing but the truth? Thank you very much. You can have a seat. If anyone has any cell phones, if you could silence those so they don't interrupt our proceedings, that'll be appreciated. The city will call the cases up, not necessarily in the order on the agenda, but I think in the order that folks may have signed up. And we will proceed case by case that way. I'll hear from the city, then I'll hear from, when your case is called, come on up to the podium to my right. Once I'll hear from the city, I'll hear from the respondent, probably be some questions and some back and forth, and then I will, in all likelihood, enter an order today on the request for the reduction. So let's go ahead and get started.
Other matter number 3, CE 1807-0264, 4331 Leicester Court.
Mitch Posner, Code Enforcement. Case ending in 264, 4331 Leicester Court. If it's pronounced that way, I'm not sure.
Leicester.
Leicester Court?
Leicester Court.
Okay. 4331 Leicester Court. Date ordered 9/19 of 18. Fine started 11/19 of 18. Ran for 298 days. Total 29,800. Daily fine is $100 a day. Date of compliance 9/13 of 19. It is the same owner. We've got no mitigating factors. The application states the contract was signed before the lien was recorded, but they purchased the property in 2014 and the lien was recorded in 2018. So I don't know if that has any bearing. City's asking for 30%.
You said the property was purchased in 14 and the lien was recorded in 18. Is that what you said?
Yes, sir. So saying that the contract was signed before the lien was recorded doesn't seem to have any bearing unless there's some other contract that would be relevant.
All right. Yes, sir.
Yeah. I bought the house in
Let
2014.
me get your name and address.
Oh, sorry. Gary Murray, 4331 Leicester Court.
Okay, thank you, Mr. Murray. Go ahead.
I bought the house in 2014, as he said, but I haven't lived there since 2017. I rented it out. And then I got a letter in the mail at my house saying there's a lien put on the property. And that was December. But I signed a contract to put a new roof on in November, which I have right here. So I didn't know there was any inspections or code enforcers going out there. So it needed a whole brand new roof.
So the case was a 2018 case.
Yes, sir.
Okay.
So you're saying the roof contract was signed, but having a signed contract doesn't repair the roof, and notification was proper.
So the first question, so was the roof contract signed because of the code enforcement case, or had you?
No, before I didn't even know about the code enforcement till like 3 weeks after the contract was signed. Okay. So I didn't get any notices, no letters, not even a phone call, nothing. So I didn't even know they were looking at it because it needed a brand new roof. So I had a tarp on it until the new roof.
Okay.
Okay.
And it took over a year to get the new roof because of the shingle.
Sir?
Yeah.
So if my understanding is correct, basically they had already planned on replacing it. They had a signed contract, but notice was due and proper. It basically comes down to they weren't aware. The case was cited in July of 18. The permit for the roof wasn't submitted even until January of 19. July of 18. And the permit wasn't submitted till January of 19. Date of compliance is when they passed the final inspection, September of 19.
Okay, so the notice of violation was dated in July.
Yes, sir.
The roof contract was,
In November 19th. But I never got any notices. I didn't even notice it was coming up.
The permit was issued in January, you said?
Permit was submitted January 3rd of 19, was issued February 11th of 19, but they needed to pass the inspection to comply, which was September of 19. I am showing the certified mail was returned. They didn't sign for it, but it was also posted to Property and City Hall as is needed.
So contract in November, permit applied for in January, the work was done in September, completed in September?
The inspection was completed in September. They could have finished it sooner and not notified the inspector. I don't know.
Okay.
I think it was finished in September, to be honest with you. It's just they had a problem getting the tile. So
I'm sorry?
they had a problem getting the tile. That's why it took so long.
Title for?
But the tile.
Oh, the
for the
tile,
roof.
the tile, they had a problem
Sorry.
getting the tile you needed, I apologize. Okay. How much did the roof job cost?
16,000.
Sounds about right.
I have the contract here if you want to look at it, with a letter of intent from the roofing company. I didn't know they waited till January for a permit. I mean, that's ridiculous if you ask me, but
Okay. The city's recommendation is roughly, I'm not reducing this to roughly $9,000. Okay. Is there anything else you'd like to tell me, sir?
no, I didn't get any notices. I didn't know at all. Because there was damage. I know it needed a brand new roof, but I also had to come up with the funds, and I was shopping around for quotes and stuff. I did this contract before I even got the...
And the notice was sent to the
The address in Royal
2704
Palm Beach that's listed with Papa.
I beg your
I don't even-
pardon?
It's the address in Royal Palm Beach that's listed on the Papa.
Yeah, the 2704 Pienza Circle,
Yes,
Royal
sir.
Palm Beach.
Yes, sir, but also posted to Property and City Hall.
Yeah.
There's no significant owner history to report. 30% request is standard for same
No, I
owner
see.
violation.
So the notice was sent to the correct address, whether you got it or not. Under the law, what's required is that it's sent to the address that the property appraiser has on record, which is the Royal Palm Beach address.
Which is correct. I got one notice.
Yeah.
And he said it was posted to the door of the house of Leicester Court.
Yes,
I asked the tenant, and he said never got anything.
That's
why
common. I understand that's a common
Like, I
occurrence,
don't live
but
there, so I didn't get it, and this is what they're telling me.
All right. Here's what I'm going to do in this case. I'm going to take into consideration the city's request, take into consideration the amount of money the respondent spent on the roof and the total amount of the lien, and I am going to reduce this lien amount to $4,140 payable within 30 days. Can you do that within 30 days?
I'm gonna have to try.
I can give you I can give you more time. I don't have any
Yeah, I'm gonna
problems.
need more time because
60 days?
if we do 90,
I can do 90 days. I don't have a problem with that. That's 3 months. Does that work?
yeah, I mean,
Well-
anyway, I can get,
the city would have no objection to 120 days. We'd like to see it get.
Okay, I'll do
Taken
4
I can
months.
get down lower.
120. I'm not going to go lower on the amount, but I'll extend the timeout. I have
And
no
do the
problem
time
with
out.
that. I'll give you 120 days. That's 4 months. So that's middle of February, I guess. Middle of March. Okay. I'll sign that order.
When you're ready to pay, at the bottom of that order, it tells you how you can remit payment, okay?
Thank you.
Other matter number 4, CE 1702046794 30th Street.
Good morning. Good morning. Go ahead, whenever you're ready.
Yes, sir. Case ending in 467, 944 30th Street, date ordered 4/5 of 17, fine started 5/6 of 17, ran for 712 days. Total is $71,200 at $100 a day. Date of compliance 4/18 of 19. Same owner. The mitigating factor on the application is it was sent to the property address instead of the owner's address, but they didn't change the information on Papa until after this case was sent. I don't have the date they changed it, but I do have the original notice of violation with the Papa sheet at the time.
Okay.
I mean, the culpability is completely theirs. There have been 5 cases on the property under their ownership, and they have 2 additional properties that combine for 17 other cases. Additionally, the owner, this is under the LLC, additionally, the owner has properties under their own name, which totals 16 cases, including 2 liens, one of which is $131,000 and still accruing. And repeated citations for no rental license. So we've got an extensive history here as well. The city's asking for 50%.
Okay. Thank you. Yes, ma'am.
Yes, I get this. I never heard
Let me
about.
get your name and address first.
My name is Abeba Jaradat, 944 30th Street, West Palm Beach.
Let me have you pull the microphone a little bit closer to you so that we can pick you up.
Okay, sorry. Abeba Jaradat. The address is 944 30th Street.
Okay. All right, what would you like to tell me about this, ma'am?
This, I never received any letter or anything like that, but they told me after I was really sick. I have stage 4 cancer, the 2 years, and I was in hospital, in and out. Then they told me there is a lien on the property because of sanitation, and they just, but I did clean that time. When the people who live there, they left the house and but I didn't know there is a letter or any violation from the city. I always respond anything, and I respect the city.
So this is a
Code
rental
enforcement.
property that you own?
Pardon me?
This is a rental property that you own?
Yeah.
Okay. Okay.
So I just, I don't have no idea this is happening.
And the
And
notice,
when I heard about it, I just tried to work with all the people who in a code violation. I try all my best to do the right thing, and
the notice was sent to the Port St. Lucie address, or was there a different address at the time?
It was a different address at the time. I have this right here. When it was cited, and it was sent to the same owner name, but the mailing address on the Papa sheet is 944 30th Street, the same as the notice of violation.
but I always I put my
Oh, okay.
my residence address, because sometimes people rent, they don't give you anything, they destroy some stuffs. But I cleaned the place after the guy left the place. And I do all my best to clean,
Okay.
and all this is, it's just debris on the property, but I ordered the container to remove it. And I was in the hospital in and out. 2 years, I was like very sick. I can give you the hospital paper. Well, I was taking chemo, and I don't even move myself.
I understand. You testified there were 5 other cases on this property? Are those all in compliance?
5 other cases on this property, 17 cases on 2 other properties in the same LLC, and 16 cases on the 5 other properties they have under an individual name instead of an LLC. So we're talking over 40 cases in the last decade for, we're basically dealing with absentee landlords. The city's managing the properties for them.
On this property, are the other five in compliance at this point, or are we?
Yes,
still-
sir. They're in compliance or we wouldn't be here.
Okay, fair enough.
I get the house like 5, 6 years ago, maybe the previous, I don't know.
So this case was a 2017 case. The other five, were they, in terms of proximity and time?
They're all over the last 8 years. I don't have the exact dates. I can get them for you, but I don't
No,
have that in front of me.
and do you know, in terms of notice, are they all sent to the same place?
I haven't checked notice on the other cases.
But they were all brought into compliance,
They were all brought into compliance, no fines.
and no fines?
Right.
Gotcha.
No fine. I don't think any of those actually even went to hearing.
Okay. Ma'am, do you have any sense for how much you spent to bring the property into compliance, what the cost was?
Wow, what did you say?
Do you know how much it cost you to bring the property into compliance in this case? I don't know if you know that or not. Doesn't look like there were
I
any,
don't have any
it
record.
looks like it was just minimum property standard kind of things.
Yes, sir.
Yeah,
Okay.
and it's just miscommunication, and I cleaned it on time, the property to re-rent it. But we didn't I don't have no knowledge of anything going on like this. I'm just really shocked.
Okay.
Because always when they send me a letter, I respond. I try to do my best because I'm full-time work and try to maintain this. And I do this in the middle. I was really, really sick, but I maintain everything whenever I get,
Is the property occupied now? Do you have tenants there now?
yes.
Okay.
They do have a valid rental license.
Okay. All right, anything else, ma'am?
Just I'm asking if, just to consider all the circumstances, because I didn't do this by just neglecting or anything. Just I didn't know it, and I was very sick, and I have medical problems and financial problems, so I didn't really hurt anybody. Just this happened, and if I can pay the administration fee and.
Okay. So I've taken into consideration the city's request to reduce it no more than 50%. The total amount of the lien right now is $71,200. Based on everything I've heard, I will agree to reduce this lien to $15,000, payable within 120 days.
50,000.
Yes, ma'am. That's reducing it by 75%. I think that's reasonable and appropriate in this case. And I'll give you 4 months to pay that. Sign that order. Okay, thank you.
Can you make a little bit less than that? Because it's 4 months is very short period for 15,000.
Does the city have any objection to giving additional time on that?
No objection, but no more than 6 months. Otherwise, we'd be creating new precedents.
I'll go 180 days. But that's it. Don't ask for more, because
180
180 days
days.
to pay the
Okay.
15,000.
Can I get any reduction? Because I have a lot of medical bill. This is very hard for me.
No, that's my best. That's what I'm doing.
Okay.
Thank you.
115.
It's on your order here, if you'd like to take a copy of
Okay.
that with you. Okay.
All right, where are we going next?
Other matter number 11, CE 18040632, 610 Clematis Street, Unit 721.
Case ending in 632, 610 Clematis Street, number 721. Date ordered 6/6 of 18, fine started 6/22 of 18. Ran for 392 days, total $39,200. $100 a day, date of compliance 7/19 of 19. It's going to be the same owner, this was for no rental license. It's the second time the property was cited for no rental license. There were 3 other properties that we needed to check. All of those were cited twice for no rental license. So we've got an ongoing issue with this. The only mitigating factor is a change of management, but it's still the property owner's responsibility. Between the 4 properties, we've got 6 years of renting without a license. City's requesting 50%.
Okay. Okay, let me hear from,
Good morning, Nora Chirinos. I'm the attorney for 4Dog LLC, the current owner of the property.
Okay.
Would you like my firm address or the property address?
that's fine.
Okay. I would like to clarify some of the facts, just to give you a background story of what happened. In 2016, for financial reasons, the owners of KIK International Group LLC, which are exactly the same owners, wife and husband of 4Dog LLC, decided to transfer all the properties owned in West Palm Beach from KIK International Group LLC to 4Dog LLC via quitclaim deed. At that time, all the rental licenses have always been under KIK International Group LLC. In 2016, they paid the licenses under that name. In 2017, once again, they paid the licenses. And in 2018, again, they paid the licenses under KIK International Group. Yes, they didn't take the time to contact the city and change the name on the licenses, but the property had rental licenses for all the properties in West Palm Beach. So I'm not sure where the city can conclude that over the course of 6 years, the properties have not had any rental licenses. They have had rental licenses. They just had them under the old LLC, which is also owned by the same owners. If you take a look at the order.
Objection,
including
sir.
the
We
fine-
seem to be arguing the original case over again.
Well, no, I want to hear this.
If you take a look, the order imposing the fine was entered on July 18th, 2018. I have before me the license for KIK International Group, which is the previous LLC that owned the property, that was current and didn't expire 2 months after the order was issued. So this license would have expired in September 2018.
All right, so that's the license
So, correct. So KIK International Group LLC is owned by a wife and husband.
No, I get that. I guess I understand. You're saying that there was in fact a rental license, but it was paid for and by and issued to the LLC KIK International.
Correct.
Instead of 4Dog LLC.
In May 2018, the property owner decided to change property managers. At that time, the new property manager, which is Deluxe Realty, gets the notice of violation for 3 of the properties, saying that they don't have rental license. They immediately contact the city, explain the change in name, explain what has happened, show proof of the licenses, and the city says, okay, all you have to do is file these applications so that we can properly change the name on the licenses, which they did. However, because they only got 3 violations, they only changed the name of 3 of the properties and left this unit, Unit 721, out because they didn't take the time to check how many properties are owned by 4Dog LLC.
So, I mean, is this really a paperwork issue, or because if I'm not relitigating the code enforcement case, but if it was paid and issued under a different LLC.
If the
it's
ownership
just-
changes, they need to update the license or it's not valid.
The ownership legally didn't change.
Yes, ma'am.
It went from one LLC owned by the same parties to another LLC.
Again, sir, we seem to be relitigating the original case. Additionally, their application simply claimed this was due to a change in management, and this is entirely different from their application.
Their application was
we're
filed
going to
by
consider
a
this, I'd like
property
to pull it from the
manager, Your
docket.
Honor.
Don't talk over one another. All right, so you're saying there were 4 units, 3 of them got changed correctly, this one did not?
Correct. This one was left out of the list because the new property manager only received a notice of violation for 3 of the properties. So it didn't trigger sending the changes for the 4th property.
Sir?
Is there any dispute about that?
I have no dispute for those facts at all, but I would think they're a property management company, they know they need rental licenses. It's still remiss of them to not check the other property and make sure they have the proper licensing. The license isn't valid if they change ownership, even if they change it to their own LLC.
Well, I understand, but, I don't see anything that tells me that these folks weren't acting in good faith, and if a mistake was made, a mistake was made, but I don't think that that's worth $20,000 in liens, is where my head is. If this was someone that just wasn't doing anything for anything, but from what I'm hearing, and there's no dispute that, they were proactive on this one, for whatever reason, slipped through the cracks, I have a hard time imposing a $20,000, even reducing it to $20,000, just because what I'm seeing is the city was trying, they were trying, this one slipped through the cracks, is how it appears to me at this point. Is that?
Correct, Your Honor. There was an oversight on the part of the property manager, and the owner is aware of that oversight, and he's willing to pay a fine or some type of administrative fee, but he shouldn't be fined $39,000 when he has been paying for a license. The property has been licensed, yes, we all agree, under the incorrect owner's name.
Does the city have any idea what it cost to bring the case, prosecute the case, and all the way through?
No, sir.
Do you have any idea what that? Okay. All right. Is there anything else you'd like to tell me?
No,
ma'am?
sir.
All right. Given anything else from the city?
No, sir.
All right. Given my understanding of these facts and what happened, I'm going to reduce this to $3,000. I think that would cover the city's costs. I think that that's reasonable given the circumstances. Can you pay that in 30 days?
Yes.
33,030. Okay, thank you.
And here's a copy of your order.
Thank you.
All right, where are we going next?
Number 2. Other matter number 2, CE 17030163, 1701 Village Boulevard, Unit 308.
Whenever you're ready.
Case ending in 163, 1701 Village Boulevard, number 308. Date ordered 5/3 of 17, fine started 5/14 of 17, ran for 355 days, total $35,500, daily fine $100 a day. Date of compliance 5/4 of 18. This is the same owner. The only mitigating factor is they think the inspector forgot, but they're a property management company. They know these things have to be inspected, and they should have been calling for an inspection.
They say that again? They say the
The inspector forgot to inspect it.
Okay.
That's what they have on their application. They manage literally hundreds of properties. They know inspections must be completed to get the license. The failure was on their part, not the city's. Of the 17 properties inspected for this lien reduction, we've got 11 cases, 9 of them for no rental license, 4 for work without permits. Clearly, we're dealing with continual behavior of violating city code on what needs to be done. City's asking for 50%.
Did you say there's 17 units, or there's 17 units with code cases?
There were 70 properties we had to inspect under same ownership.
Okay, 17.
And they combined for 11 other cases,
Gotcha.
9 of which were no rental.
Okay. All right, yes, ma'am.
Hi, good morning. Florence Turgi, 17650 Northeast 19th Avenue, North Miami Beach. So I am the property manager of this property. In fact, what happened, I apologize because I think it was a misunderstanding. We didn't say like he forgot, we forgot. In fact, my case is a little bit similar than the previous case. We took over management. We had 41 property at once, switching management, and 29 of them was like different LLC, never the same owner, but under West Palm Beach. So what we did, because the management company was not like very compliant in forwarding us the documents on those property, we asked for the certificate, the business license, and everything to put them in the file, and they didn't. So what we did, we contact Mr. Lavin, the business tax officer in West Palm Beach, to double check all those property. So we sent him Excel sheet, with the list, and he was sending us back to us in red, in yellow, in green, which one was in compliance, which was not. So in fact, we realized like some of them just needed like the payment for the business. Some others needed a reinspection to be inspected. So we were coordinating, it's true, those inspections back and forth, but it's a lot of property at once. So we did our best, but the thing is the person in charge doing that left with 1 week notice. So the new person took over, and I think she forgot that one. She sent the payment, but it was never re-inspected until we went on compliance later on.
Okay.
And for all the other cases, we are working since like months at 2-3 persons every day with the code enforcement, Monique at the city, to comply for all of those. And it's not like, it's all of the result of the previous management company who didn't do the job, and we were not aware, and we inherited the problem. So as soon as we are aware, we are fixing it.
When you had that spreadsheet and you were in discussions,
Yeah,
when,
it was in
that
March.
before the code enforcement case? Was that after the code?
We were talking in March, the end of March 2017, because this is when we took over, most likely. And the thing is, we were doing one by one, like also the change of addresses and everything, and this one just the same address, like we didn't receive the notice.
Okay.
Because the lien, I think, was recorded on June, so.
And so, can you help me again, when, if that was going on in March, when was the code case again? Tell me.
The code case was opened in March of 17.
So about the same time.
It
Yes,
was
sir.
beginning of the month, March 7, and we inherited on March 23rd,
Okay.
While there were, of course, 17 properties involved in inspecting this, the case itself was just on one property. It was cited beginning of March, went to hearing May 3rd, and was given another amount of time to comply, and they still didn't get it done. We're dealing with two bad trends here. One is continual management of the city instead of the property management doing what they're supposed to be doing. We've got to go in and cite them. And based on the last case and now this one, if you change management companies, then you've got a reason to say, oh, it wasn't our fault.
Well,
Sorry.
I'm going to disagree with that. I think if you change management companies, that's one thing. And regardless, to me, are you showing a good faith effort? You know, I understand things happen, but if you're showing a good faith effort, that means something to me. And just by virtue of changing management companies does not give you a free pass in my eye. But changing management companies and trying to do the right thing, that's what I'm looking at. So I wouldn't
If I can
agree.
say something else, the thing is like we inherited, like it was the violation was the beginning of March, we inherited mid-March. So I automatically, you know, at the end of March back and forth with Mr. Levine, and after the code enforcement department, like coordinate all those things. But I try to do it like right away, because the thing is like, we inherited all those mistakes, and it was a lot of property, like all in once. So,
And all the other ones got done correctly?
Yeah.
Okay.
and we even sent the check for the payment of the license in 2017, and go on.
Okay. Anything else you'd like to tell me, ma'am? Anything
No,
else from the city?
No, sir.
Okay. This lien currently is at 35,500. The city's recommendation is 50%, which is 17,750. Given everything that I've heard and the testimony about what happened, I do look at this one in a similar light as the last one. I'm going to reduce this also to $3,000 payable within 30 days.
thank you, Your Honor.
Okay.
There you go. 7, 8, and 9 are obviously wrong.
Which are?
7, 8, and 9. Do you want to together?
Yeah, if 7, 8, and 9 are together, we can, I mean, I think we'll have Mr. Posner tell me about them separately, but we can do them all. Yeah, that's usually how we do those, so let's do that.
Certainly no
matter-
objection here.
Pardon?
Certainly no objection here.
Yeah, let's go ahead and,
Other matter number 7, CE 16030142, 9901 Baywinds Drive, Unit 3304. Other matter number 8, CE 16030152, 9873 Baywinds Drive, Unit 5301. And other matter number 9, CE 16030154, 9849 Baywinds Drive, Unit 8101. Same owner.
Good morning.
nope, good afternoon.
Already good afternoon? Yes, you are right.
Go ahead.
Okay, hopefully I've got these in the right order now. Case ending in 142, 9901 Baywinds Drive, number 3304, date ordered 420 of 16, fine started 523 of 16. Ran for 1,180 days, $118,000, daily fine of $100 a day, date of compliance 8/16 of 19. Same owner. Case ending in 152, 9873 Baywinds, number 5301. Date ordered 420 of 16, fine started 523 of 16. Ran for 257 days, $25,700, $100 a day, 2/4 of 17. Same owner. Case ending in 154, 9849 Baywinds, number 8101. Date ordered 420 of 16. Fine started 523 of 16. Ran for 984 days, $98,400, $100 a day. Date of compliance 2/1 of 19. Same owner. The rest of the information is the same on all three cases. All three cases are for no rental license. All three properties were cited previously under the same owner for no rental license. And again, the only mitigating factor is they're blaming poor management.
When were the prior cases?
2 years prior on all three.
So those would have been, 20,
The only reason we're not I'm sorry?
those would have been like 2016 cases?
Right.
Okay.
Well, no, these are the 2016 cases. The others were 2014.
I'm sorry, I was looking at the code section, I saw 18. My bad. These, right, 2016, so
Yes, sir.
the prior cases were 2014 cases.
Right. The only reason we're asking for 30% rather than the 50% the same as the others, is 2 of these are six-figure liens.
What happened with the 2014 cases? Do you know, did they
They all got complied, and then they
before
turned,
hearing or whatever, or both?
before a hearing. They all
Before.
got complied before a hearing, then they turned around and violated again.
Got it.
Apparently because of poor management based on their application.
Um, And I know that you said it, they all have different lengths of time they were in violation. Did they all come into compliance at different time? The compliance dates, were they all the same, or were they?
Now, one of them was complied less than a year later.
Okay,
One of them ran for over 1,000 days, and the other one ran for just under 1,000.
so this wasn't like, oh no, we have all these outstanding things, let's comply them all at the same
No,
time. They
haphazard.
complied from time to time.
Complied in a haphazard manner.
Understood. Okay, let me hear from respondent. Yes, sir.
Hi. Yes, there was some non-compliance in 2014. We did comply. Now, you cannot comply all at the same times, Mr. Davis.
I'm sorry, sir, can we find out who he is?
Yeah, let me get your
Relation
name
to
and
property?
address, please.
Uri
Thank you.
Segev, I am the owner of the company and the manager of the company that owns the units.
And I didn't get your name.
Uri Segev.
Thank you, sir.
Okay.
Go ahead.
Thank you.
Regarding the 2014 case, you were questioning if they were all complied at once or one by one.
No, that was a question for the 3 that are before me, the
Correct.
2016. Not-
Let me explain.
Go ahead.
In order to comply, you need to go through inspections. In order to do inspection, you need to schedule it with tenants. Not all tenants are happy to comply or help us. So it takes time. So you cannot comply with all at once. You comply the minute you can get the inspector in and inspect the unit. At times it fails, at times it passes. At times you need to call another inspection. So it's not that you are not trying to do it all at once. It's very efficient to do it all at once. But you have, let's say, 3 different tenants that needs to be there at the same time. So it can never happen all together. The 3
Understood.
cases we are talking right now, 2 of them, and I'm sure the gentleman from the city will attest to that, 2 of them have been ready for mitigation for like a year or 2. It's only one of them that we could not get the inspector in because the tenant would not allow us. When she was not there, she was very picky. We needed to wait until she moved out. Then we called inspection, and that's why we're here on 3 units. 2 of them have been complied long time ago. Just the city would not let us mitigate one by one because they said, finish everything, it's one company, come with all of them together. So it's not that you do not want to comply, you do. But at times it takes months and months until you can get an inspector in. And at times you get failed, you don't even know for what. It could be a very minor reason. The inspection for rental is very, I want to call it somewhat picky. You know, this window looks a bit unclosed well. You need to fix your window. We do it, but that's life. By the way, those units, only so we are on the same page, relatively very new units. I think 10 years old, if I'm not mistaken, maybe 12. We are not talking about units that are poor rental, actually high quality, Mezzano condominium, if you know. The minute we got notices, and the city is correct, some poor management at one point, there was a manager, she sent the application, but she did not send the check, or maybe just the check was sent without the application. Not real reasons, but the minute we jumped on it, we tried to do those inspections, pass them, and come for mitigation. I have no joy to come here and try to defend. By the way, the prior cases, everything was compliant. We never needed to come over here and fight any mitigations. Everything brought into compliance. That's all.
Right, and that's what the city said, that you were cited all 3 of these in 2014, but were able to bring them into compliance without the need to even go to hearing.
Correct. We also have other units that are all in compliance and never had any issues. This is not my only properties in Palm Beach. Sorry, in the city of West Palm Beach.
Sure, if I can respond to all that?
By all means.
He kind of made one major point for us. I mean, the fact that it took a while to comply because there's a tenant in there is the issue at hand. He's renting it with a tenant in there and no rental license. That shouldn't happen. It's supposed to get rented beforehand, and then there's not a scheduling problem in the first place because you don't have to schedule it with a tenant. And frankly, it really has no bearing on the actual violation itself because the violation is for renting without a license.
Correct, but you need to renew every year, and if the tenant stays, there is a tenant there.
It doesn't need to be re-inspected every year as long as it's the same owner.
As far as I know, all the time they told us to schedule inspection. Happened to us constantly. Constantly. I wish it was that easy. I wish working with the city on those inspections was easy. I'm not saying it's difficult, but it's definitely not easy. It's another hurdle. And you know that. You know how long, you know how many times Anna was on the phone with the lady at the office trying to schedule inspections. And you always require that somebody from management will be there. So we need to send somebody from Miami to meet them. You know, it sounds easy, but it's not. Here, when we sit here, everything sounds easy. In practice, somebody needs to be there, meet the inspection, meet the inspector, tenant needs to comply. It's not the easiest task in the world. But yet we did it.
Okay. All right, anything else from?
No, sir.
Anyone? Okay. So in this case, we're talking about, we have three units, a total of 220, almost $250,000 in liens. And I'll break these out individually, don't worry. City's recommending that they be reduced to no more than 30% of their value, which would bring the first one to $35,400, the second one to $7,700, and then the third one to just under $30,000. So with the city's recommendation, we're looking at 65, so about $73,000. Based on everything I've heard, which includes the fact that there were the 3 cases in 2014, and they were complied in time, and that's important to me because it shows me that you know how to comply these in time. But in this time in 2016, that didn't happen. So I have a little less sympathy than I may have had for some other prior requests this morning, and that's a big part of the reason why. So here's what I'm going to do. In the case ending in 142, that's agenda item 7, I'm going to reduce that one to $15,000. I'll reduce the one ending in 152 to $3,000, and I'll reduce the one ending in 154 to $12,000, all payable within 180 days.
I'm sorry, sir, what was the amount on the second one?
It's 3.
Yeah,
3,000?
Sir, about the first one, $15,000, we are talking about a fine which the city has no cost associated. It's not like we have a property that is a barrens to people that drive around and they see an ugly property with garbage. We are talking rental.
I understand, and I think I articulated my rationale for why I did what I did, but I essentially reduced $250,000 down to a very small fraction of that. So I think that that's reasonable given the circumstances with this particular case. Thank you. Where are we going next?
Number 10, CE 160702893486 Briar Bay Boulevard, Unit 205.
Good afternoon.
Whenever you're ready.
Case ending in 289, 3486 Briar Bay Boulevard, number 205. Date ordered 9/21 of 16. Fine started 10/24 of 16. Ran for 1,006 days. Total $100,600, $100 a day. Date of compliance 7/27 of 19. Same owner. This is another one for no rental license. It was rented for 4 years without it, and the only mitigating factor is wasn't aware I needed a rental license. The city is asking for 30%.
So you said it was rented for 4 years with no rental license?
Yes, sir, before they got cited and had to comply with the case. But if they, if they didn't know, that is a normal occurrence, but lack of knowledge still comes down to the owner's responsibility.
You're recommending 30%?
Yes, sir.
All right, let me hear from the respondent. Good afternoon.
Hi, good afternoon. This property was listed for sale. We got a contract, and while we were under contract,
I'm sorry, I didn't
Lisette
get your name.
Ludmir, my name,
Yes. I'm sorry, can you tell me again?
everything?
Just your name.
Lisette Ludmir.
Thank you, ma'am. Go ahead.
This property was listed for sale when we were under contract. On the lien search, it popped up that there was a lien on the property because it didn't have a rental license. The property had a property management company, I don't know for how many years, another one, and it seems that they never request the license. So as soon as I got the notification from the title company, I'm a real estate agent involved in the sale, I called the city to ask which was the problem, and well, there is when we start all the process. The city was notifying an address from the owner. The owner doesn't live in the States, so the address where they were notifying, nobody lives there, so nobody was aware about this situation. So as soon as they told me what I need to do, I start the process. We request the license. We pay everything that the city requests from us. They went for the inspection. There were a couple of things that we need to address. One of them was replace a window. And to replace a window, they don't have it in stock, so we wait like 2 months or 3 months for the window to have it ready, and then they re-inspect. We pass inspection, we had the license, and from there we request like the lien reduction. Now we are still under contract, and we have been extending the contract while we wait until the hearing.
And it was Concepts and Ideas LLC for the
Yes, sir, and it was sent to the address listed on
Weston
PAPA.
address? Okay.
Yes, sir.
Okay. And so I mentioned this before, legally, the city is required to send the notice to the address that's on record with the property appraiser, which is what happened. Even if it wasn't actually received, that is considered legal notice.
But well, as soon as
Pardon me?
we, noticed that there was a problem here, we
Sure.
took action.
Okay.
If I could point out, sir, again, it wasn't written on the application because all they put was that they didn't know, but based on testimony, we're again dealing with poor management because they had a management company that didn't apply and didn't change the proper notification address.
Okay. Anything else that you'd like to tell me, ma'am? Anything else from the city?
No, sir, just, except that the ask is 30% because that's standard under same owner and not an extensive history.
All right, so 30%, this lien is at about just over $100,000. 30% would bring it down to $30,000, more or less. Based on everything I've heard, I'm going to agree to reduce this to $10,000, payable within 180 days.
Thank you so much.
Thank you.
Yeah, when you're ready to do that, I'm done with that order, tells you how you can remit it, okay?
to next.
Other matter number 5, CE 181101673008 Broadway has rescheduled. And other matter number 1, CE 10060204 1100 Palm Beach Lakes Boulevard. And other matter number 6.
We're doing these together? I'd rather keep them separate because they're
Okay.
very different.
1 and 6, yeah, they're different owners, different addresses. Is there a reason to consider them together?
Same applicant, put it that way. Under different ownership names. And in the case of 1100, you're dealing with a prior owner applicant, actually, so they don't still own it.
Let's just do number 1, and then we'll do number 6, or let's, I think if you're not going to confuse the record, you're going to confuse me if we try and combine these, so let's do them separately.
Ready?
I don't care which one you want to do first.
Palm Beach Lakes.
Okay, so that's agenda item number 1.
Yes, sir.
Okay.
All right, case ending in 204 for 1100 Palm Beach Lakes Boulevard, date ordered 7/28/2010. Fine started 6/9 of 2010, ran for 30 days, $3,000, daily fine of $100. Date of compliance 7/9 of 2010. In this case, we're dealing with a new owner who purchased the property in 2010 with the lien already in place. I also need to point out that when you see the PAPA sheet, it's actually going to say 1110 Palm Beach Lakes because the numerical changed, but the partial number is the same as the original case. Under this ownership, we're dealing with 8 cases. Owner history in the city is over 60 cases over numerous properties, and history of transferring. What we've got in the last 6 months is 13 properties transferred to their own individual trust to basically subvert the lien reduction process. City's asking for 50%.
Yes, sir.
My name is Nicholas Arsali. I'm here actually on behalf of Anthony Arsali, who is the trustee for the trust, and he couldn't make it here. I'm going to be reading the statement that he put into the application, and that's going to be for the record. The subject property was purchased through a tax deed on 9/1/2010. The subject lien was recorded just 3 weeks prior to the sale, and given the timing of the recording, it was not shown on the clerk's title search. The owner only became aware of this lien in August of this year after conducting a title search for the upcoming sale of property. At the time of the lien, the property had been abandoned and the property was being maintained by the city through various work orders that were also liened against the property, and all have been paid since then. With respect of this lien, the notice went out and the city contracted to have the issue resolved 30 days after the notice went out. Because the city considered the violation a repeat violation, the lien occurred from the date of the notice. Given the circumstances of the lien, the fact that the delay was due to contractors' inaction in fulfilling the work order and the current property owner absolute lack of fault with respect to the lien. The property owner respectfully requests that the lien be released or at a minimum reduced.
Okay, anything else from the city on this one?
The city agrees they purchased the property with the lien in place, did not cause the original violation, and agrees that it should be reduced.
I mean, this is a $3,000 lien. The city's recommendation is a 50% reduction to $1,500. That probably doesn't cover the city's costs in this. I'm inclined to accept the city's recommendation and reduce this to $1,500 payable within 30 days.
I'm sorry, how much was that?
Pardon me?
How much was that?
1,500.
Okay.
Other matter number 6, CE 19010143, 5701 Broadway.
Okay.
Case ending in 143-5701 Broadway, date order 26 of 19, fine started 2/22 of 19, ran for 63 days. Total is $15,750. It was $250 a day, date of compliance 4/26 of 19. Same owner. Sir, you've already heard all of this. You had given the applicant the opportunity to return at a later date once they finished all the work they were doing on the property. So just a brief outline rather than presenting everything again. Based on the extensive owner history, 13 properties removed from the lien reduction process by transferring to individual trusts, and community concerns, the city's ask is still 50%, and I have 2 members of the community that wish to speak.
Okay, go ahead and have them come up.
They have not been sworn in.
Okay. Do you swear or affirm under penalties of perjury that your testimony will be the truth, the whole truth, and nothing but the truth?
Yes.
Thanks. Why don't you come on up one at a time and tell me your name and address.
Angela Ogburn, Northwood Harbor Association Board Member, West Palm Beach. So we've been here before.
I recognize y'all.
Yes, there's been a lot of work done on this property. It's not quite up there yet. We are recommending that you follow the city, not going less than 50. There are still open permits on this property. We're not sure who's doing the work on the property. Is it the owner or is it the tenant? And if it's the tenant, there's still not a business license or a rental license on the property. That expired in September. We just want to make sure that this property complies and stays, because it is setting precedent for the whole Broadway corridor.
Okay.
Carl Peterson, President, Northwood Harbor Neighborhood Association.
Yes, sir.
I'll just reiterate on what Angela says. This is the entry to our city, and we're all working very hard to make Broadway look as though he's going through improvements, and he's doing a lot of things. But you know, we found sometimes once people are off the hook, it stops. So we just want to make sure, and he certainly has done work to show us that things are moving forward. But I think there's a little more work to be done before we get to the finish line, and we just want to make sure we get there together.
Okay. Thank you, sir. Let me ask the city, the code enforcement case is complied, even if there are some open permits and work is still being done, is that correct?
Yes, sir. That was true last time also.
Yeah, okay.
Is this working?
I'm not sure.
I heard you.
I can hear you, but I don't know if the microphone
I heard you
picked
through
up. All right, let me hear from the respondent. Yes, sir.
My name is Nicholas Arsari again. We were before you, and the question was doing final inspection on the permits, existing permit. I have a copy here. Both, they were passed. The final and CO's been done on those permits. That's why we're back before you.
Okay.
As far as the other open permit, there is an open permit for data. Basically, the water management, and the city wants to know how much they have to charge for the, what surface is concrete, what's that. So it's just a calculation data, has nothing to do with the improvement on the property needs.
Okay.
That's for the bidding purposes. There's another open permit, it's a lien reduction permit, which is there. As far as, I do have some pictures here, and the property looks a lot better than what it did or anything else on the Broadway. I would like to make the
Why don't you
picture.
show them to Mr.
Okay.
Posner, and then I'll take a look at them.
We have gone far beyond what we have to do on this thing. The worker actually done work, at night. They tried everything. The lighting is beautiful, everything, the landscape was final, beautiful. The place is just the only thing they're hoping to open up by December 1st. And It's all done. I have a picture here from
And I remember this. When you were showing me the picture of that red building, what is that in relationship to?
She had it on the wrong folder in the case. I believe that was from other properties that had to be inspected.
Okay.
It's not this property.
Okay, I very
That's why
clearly
I,
remember this one, yeah.
Ms. Ogburn actually pointed it out. That's why I went up and switched the folder.
Okay, gotcha.
And if I,
Go ahead.
at the last hearing, the city recommended 50%, and Your Honor said that in order to go, really, I want the thing to be done, I want it to be complete, and I'm going to reserve my ruling until it's all done. It's all done, the picture speaks for itself, and right now they're basically pressure cleaning and cleaning for opening, and they're hoping to get everything done by December 1st to open up. And I have to say, the property looks better, especially with the painting and everything else, than anything else on Broadway right now. It's just beautiful with the landscaping, palm trees, and everything else.
Yeah,
So-
no, I remember this one, and I remember what it looked like before, so I agree. I think you guys did a really good job on this one. It looks good.
And the issue, if I may say, the reason the whole lien came about and everything, because it is in the appeal court, there was a misunderstanding with the code officer, and what happened is we thought the order talked about completing the wall and closing the permit.
I remember.
And
I remember
we
that
did
hearing.
close actually about that, but there was some other issues that they wanted actually the business to go, and there was a misunderstanding obviously, and that's why the order went into place. So I really on this one, because we have already spent over $100,000 in this project, and any dollar more is going to be, affecting us hugely, and. So we're asking if it is possible to go down to, just the cost or zero or whatever, whatever you can do. But this one is really, we have tried.
Sir?
Thank you very much, sir. I appreciate it.
Sir, he asked if he could speak again.
Briefly.
No, we just want to clear, because the last time it was your tenant that was doing the work, correct?
We are funding the tenant, we are paying the
You're
tenant.
funding,
Yes.
but, we just like as a neighborhood to understand, we don't want to get a mix-up. Says, well, I thought my tenant was getting the permit, and he thought I was getting the permit. I mean, could he verify today who's getting vendor license and all the necessary permits? Is it yourself, sir,
So
or?
let me. You guys can have that discussion offline. That's
Okay,
beyond
all
the
right.
scope of what I'm here to do.
No, that's fine.
But I hope that you're all good neighbors and have those discussions and understand what's going on, and to the extent you can. Because it's very clear to me you've done a great job on this. It's also very clear to me that these folks are passionate about their neighborhood and they really want it to be a top-notch place. So it sounds like everybody's kind of got the same goal in mind, and I really encourage you to keep that in mind. So thank you very much. What I'm going to do in this case, the lien is $15,750. Based on everything I've heard and my understanding of this case and my recollection, I'm going to reduce that to $4,000 payable within, can you do that within 30 days?
We can
I'll
do
give you
30
more.
days, but if it's a little bit less than
Yeah,
that,
no,
really help us a lot.
I'm not going to go less on the number, but I'll go more on the number of days. I'll go out to
30 days would
30,
be.
okay.
Yeah, we need to get it off the property.
Very
because
good. All right.
Thank you.
I think that's all of, is that it? Anything else that I need to worry about today in the city of West Palm Beach? All right, then it's 12:37 and we stand adjourned.